Welcome to another exciting episode of Hot Topics in Estate Planning and Probate with Lorie Burch. Our question today comes from Jim in Ennis, Texas. He writes, "Dear Lorie, my will was created years ago, actually decades ago. That happens a lot. And I decided that it needs to be updated since so many things have changed. I will not bore you with my family's history and drama." Too late, Jim. "But there are legal steps I'm wondering whether I can take to ensure certain individuals will not be included with any inheritance distributions I allocate. I thoroughly enjoy your Hot Topic videos and find them extremely helpful." Well, thank you, Jim. I appreciate that. Jim in Ennis, Texas. Yes, well, first and foremost, you definitely want to make sure that you keep everything updated. There's a lot of changes in the law, a lot of changes to your circumstances. My website has actually a really great page that goes through some of the triggers that you may want to think about that may be time to review. One of the changes in law that's happened most recently in the last several years is HIPAA, which refers to the Privacy Act of Medical Records. If you don't have HIPAA addressed through your medical power of attorney or through a separate document, you're going to want to make sure that you get that at least updated. So very good to update. Now, it's also important to keep your beneficiaries updated. Life insurance, retirement, investment accounts, because those function independently of your will. So that is things you should consider to keep things updated. Now, as far as disinheriting people, that is a very important point, Jim, because it's not just a matter of naming who you want to make decisions, who you want to be executor, who you want to make medical decisions. It's also a matter of naming who possibly you don't want. And you certainly can exclude people, but you need to make sure that that's written in the will and other documents. Now, it's quite often, or quite common, to use what's called a no contest clause in a will. And that's basically where you're saying that if anybody contests this, then they get nothing. And that's all fine and good, and they do carry weight in Texas. However, you may want to go a step further than that and actually specifically exclude family members from either making financial decisions through powers of attorney, being your guardian, being guardian of kids, being executor, what have you. So it is a good idea if there are people that have kind of surfaced and not shown themselves to be the most reliable or trustworthy individuals, that you specifically update your documents for that. So great question, Jim. Hope you're staying cool down there in Ennis. If anybody has any other questions for us, please submit them via the Lorie Burch mailbag on Facebook. And speaking of Facebook, please make sure that you like us. And if you have any other interests in other hot topics, please make sure that you visit our YouTube page as well as the website that I mentioned earlier. Until next time, remember, if you don't have a will, the state of Texas has one for you.